Can a seller back out of an accepted offer? You found the house. You made the offer. The seller said yes. You're already picturing where the couch goes, and then the seller calls and says they changed their mind. Can they actually do that? And if they do, what happens to your money? Stick around because the answer might surprise you. Welcome to Know the Law. Today we're breaking down one of the most stressful situations a homebuyer can face. A seller who wants to walk away after you've already signed on the dotted line. By the end of this video, you'll know your rights, what the contract actually means, and what options you have if a seller tries to pull out of a deal. Let's get into it. Here's the first thing you need to understand. The moment both parties sign a written purchase agreement, that contract becomes legally binding. This surprises a lot of people. Some sellers assume that because they own the property, they can change their mind whenever they want. That is not how it works. Once a seller accepts your offer and both parties sign, the seller generally cannot back out without a legally valid reason. The signed contract transfers contractual rights to the buyer. The property is now subject to the terms of that agreement, and if the seller walks away without proper justification, they are in breach of contract. That is a serious legal position to be in. A seller who breaches a purchase agreement without a permitted cause can face real legal liability. The buyer has the right to pursue a lawsuit for damages. There are legal consequences, and buyers should know they have tools available to them. Before we go further, let's talk about something that trips up a lot of people. What if you talked to the seller, they agreed to sell, but nothing was written down yet? Maybe it was a casual conversation. Maybe they said yes on the phone. You might think that counts for something. It does not. Under a legal principle called the statute of frauds, verbal agreements to buy or sell real estate are not enforceable in court. Virtually all states apply this rule. The agreement must be in writing and signed by the parties to have any legal standing. This is exactly why getting everything documented and signed matters so much from the very beginning. Now here is where things get a little more nuanced. Not every situation where a seller walks away is a breach of contract. Real estate purchase agreements often include contingencies. These are specific clauses that define the conditions under which either party may legally terminate the agreement. Think of contingencies as the built-in exit ramps. For example, a contract might include a contingency that allows the seller to cancel if they cannot find a replacement home within a certain window. If the seller cancels under a valid contingency that is written into the contract, they are not in breach. They are following the rules both parties agreed to. This is why reading your contract carefully matters enormously. You need to know what exits exist and who has access to them. Let's talk about your earnest money deposit. This is the good faith payment you made when your offer was accepted. It is held in escrow, meaning it sits with a neutral third party until the deal closes or falls apart. Generally in most states, if the seller cancels without a valid legal reason, the buyer is entitled to a full refund of that earnest money deposit. The money does not go to the seller just because the deal fell through. However, the process for actually getting that money released can vary. In some states, there are specific rules requiring the buyer and seller to both agree before the escrow holder releases the funds. In certain states, a court order may even be required before that money moves. So while you are likely entitled to your deposit back, getting it returned might require some additional steps depending on where the property is located. So what can you actually do if a seller backs out without a good reason? You have real options. First, you can pursue damages through a lawsuit. If the seller's breach caused you financial harm, such as money spent on inspections, appraisals, or temporary housing, you may be able to recover those losses. Second, there is a remedy called specific performance. Because real estate is considered legally unique, courts have the power to actually compel a seller to go through with the sale. A judge can order them to complete the transaction. This remedy exists specifically because no two properties are the same, and money alone may not make the buyer whole. Let's make this concrete. Imagine you sign a purchase agreement on a home. You pay an earnest money deposit, schedule inspections, and start planning your move. 2 weeks later, the seller calls and says they received a higher offer and want to sell to someone else. There are no contingencies that allow them to do this. That seller is now in breach of contract. You are generally entitled to your full earnest money refund. You could also sue for damages related to your out-of-pocket costs. And depending on your state and your contract language, you might even be able to ask a court to force the sale to happen on the original terms. You are not powerless. The contract was made to protect both parties, and it protects you too. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.